Get out of my courtroom. I'm done with you. Get out of my courtroom. Take her out of here or take her to the jail. I don't care. Get online. Do your research. That's 1 day. That's 1 day. Because you can't keep your mouth shut in my courtroom. Put her in. Put her in. Your appearances or appearance, Mr. King.
78774.
Go ahead.
Thank you, my colleagues, left the review file and the here should be a further honor. My understanding that office contacted the complainant and the complainant is not objecting to the expungement.
Wonderful.
People should disqualifying businesses appropriate for people to have that option.
Thank you. All right. Did you bring an order?
Just to completely fill out an order for this.
I was not supposed to bring anything.
Okay.
You gotta read the instructions.
Yeah. I'm going to grant your order, but you got to have an order for me to sign to make this happen. Okay. Well, it's not our job to tell you how to get your expungement, ma'am.
Take it to the court downstairs.
Okay. Goodbye. Then we're done. We're done then. See you. And you're leaving. Bye. And you want to argue with me, so leave my courtroom. I'm just telling you, it's not our job to tell you how to do this. You've chosen to do this process. We don't tell you how to do that. And I'm telling you, you need an order. So go get an order, fill out the order, present the order. You don't have an attorney. Okay? Attorneys know about orders. You've chosen to do this on your own. You got to read those instructions better because you got to have an order. I'm telling you, I'm going to give you what you want, but I'm not going to do your paperwork for you. Understood? Bye.
Okay.
Microphone voiceover. Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. You're about to witness a courtroom where patience runs out fast. What starts as a routine hearing suddenly turns into a dramatic lesson in courtroom etiquette, judicial authority, and the consequences of refusing to follow instructions. But that's only the beginning. Later, another defendant faces a life-changing decision after being accused of violating probation, and the judge delivers a warning that could turn just a few days behind bars into 90 days in jail. Stay with us, because every decision in this courtroom carries real consequences.
Get out of my courtroom. I'm done with you. Get out of my courtroom. Take her out of here or take her to the jail. I don't care. Get online. Do your research. One more word, contempt of court, 1 day in jail. That's 1 day. That's 1 day. Because you can't keep your mouth shut in my courtroom. Put her in. Put her in. What do you got?
Oh, I'm not sorry.
2 days if you say another word. Shut your mouth and go and sit down. Go ahead. Okay. Counsel, your appearance for Mr. Hart.
Good morning. 78413. MIB's counsel for Mr. Arms. You say it where?
Good morning. Counsel, I've got 2 files for Mr. Hart. One, no, that's not his. I got 1 file for Mr. Hart. November 12, 25, operating while impaired. Let's see. He was sentenced on May 14th. Fines and costs, 12 months probation, 8 days on the work program. He's here today because as part of our work program process, The supervisor took the crew to lunch, and on 2 different occasions, Mr. Hart helped himself to some food at the counter that he didn't pay for.
I talked to Mr. Hartz and he actually showed me a credit card receipt for the day in question. I don't have the amount.
Microphone voiceover. This is one of those moments where the judge sends a message far beyond this single case. He's explaining that simply presenting part of the evidence doesn't erase allegations of wrongdoing. If investigators confirm that unpaid food was intentionally taken, the consequences become dramatically more severe. The judge is also making it clear that honesty and accountability matter more than risky excuses. What would you do in this situation? Accept responsibility now or gamble on a hearing that could lead to a much harsher sentence? Let us know in the comments.
And I was asking Mr. Lilly if we could adjourn so that I can get more facts as far as what the amount that we were disappointing was stolen on that day. If it lines up with the amount on his credit card statement on the same day for at the same restaurant, we would ask the probation to dismiss that one and allow him to complete his full program.
Okay.
But we are prepared today to plead guilty to the violation of probation for the failed protest or the failure to set up protest.
We'll do it all at once. All right. So hold on. I want you to be clear on something. My understanding is that you purchased some food at the restaurant and you also took food at the restaurant that you didn't pay for. So I'll give you the adjournment. But just so you understand, today, if I find you responsible for stealing food, I'm going to give you 3 days in jail instead of the 3 remaining days on the work program. If you go through all this and it's determined that it's exactly what I say, you have a receipt for the food that you bought, but you don't have a receipt for the food that you stole, I'm putting you in for 90 days. So if you want to gamble that, you can gamble that. But I'm not asking questions right now. I'm not playing games with you. All right? So I'm not asking questions right now. I'm just telling you where you're at. I think you're playing games with me. So if you want to play the game, just you're talking, I'm not asking questions. If you want to play the game, understand that it has costs when you lose. So with that, if you want to talk to counsel, talk to counsel. If you want to just have a date to come back, I'll do that. And I'll have somebody from Blue Sky Restaurant here.
Please prepare to plead guilty to both, except the 3 days in jail.
Yes?
3 two doors and son I take care of full time.
Okay.
My mother passed away.
I'm sorry to hear that.
Outside of stomach, and everybody else take.
How old are the kids?
Sons who work, my other 2, my daughter just turned 10, Joan board.
Okay.
My other daughter is 6.
Okay.
Take care of them one time myself.
Okay.
I'll smoke weed.
I'll give you some time. I'll give you a little time to make arrangements, but you're doing 3 days in jail. You don't have to start it today. No. It's not a money thing. Like I said, I'll give you some time to make some arrangements. And I would strongly suggest the 4-year-old's probably too young, but certainly the 10-year-old is old enough to get her some grief counseling. Get her some grief counseling. And if you talk to my probation department, they can probably give you some. Emily, did you get that one I just found out about the one in Northville? Hold on a minute.
I see when I passed on North Line Road, I think it's Beacon Baptist, they have a huge thing of grief sharing. They know that's the word that you usually use to counsel.
I'm not going to find it now. Just grief counseling. I'll just say that your daughter would benefit, but go ahead. I don't care. You owe me 3 days in jail. Like I said, I'm not going to tell you to start right now. I'll give you a little time. What's that? I want the jail done by the end of the month. And that's a gift. That's a huge gift. But I'm not going to wait. You got to tell me when you're going to report for jail.
Can you
Make some phone calls. Yeah.
find out?
Yeah. In the next half hour, I want you to come in here and say, I want to report for jail on such and such a day.
Like 2 of the days could be weekend days. Saturday and Sunday, or Thursday night. And
I don't know.
Well,
I don't know if anybody's doing that now.
And it is Sumter, so I'd have to contact Huron PD, so I don't know if they're gonna do 3.
She can check, she can confirm that while he's talking to the boss. I don't care what days they are. If they'll accommodate him so he can do Saturday and Sunday, that's fine.
Next week, Wednesday, Thursday.
You sure? So that's the 24th. You'll report here at 9 o'clock in the morning. Got that, Mr. Rowley?
Yes.
All right. And once again, grief counseling.
Over 300.
That's, you still owe the money, whatever you got working out on that. Counsel on Miss Pinson's file, your appearance.
Good morning, Your Honor. May it please this Honorable Court, Vanessa Moss, P63901 of NDS, representing Miss Melissa Pinson, who appears via Zoom. Miss Pinson, could you please place your name on the record?
Melissa Pinson.
Thank you.
You're welcome.
Counsel, if I'm reading this correctly, prosecution is going to take count 1 down to a use of, right?
Yes.
And she's going to plead guilty to use of, then she's going to plead guilty to count 2 and 3 as written. Is that right?
That is correct, Your Honor.
Okay. All right. Miss Pinson, did you discuss your rights and options with Miss Moss?
Yes, I did.
You understand those rights and the options they give you?
Yes.
Do you understand the possible penalty for the charge of use of cocaine?
Yes, I do.
And do you understand the possible penalty for operating while intoxicated?
Yes.
And the charge of drove while license suspended, you understand the possible penalty on that one?
Yes.
Understanding all these things, are you pleading guilty to those 3 charges today freely and voluntarily?
Yes, I am.
Counsel, would you like to voir dire to get me the facts that support the pleas?
Your Honor, I don't have a file in front of me. I'm sorry, Your Honor.
That's
Hold
all
on.
right. I can give you an incident date. This would have
Okay.
been on October 19, 2021 in Romulus.
On that day in time, Ms. Pinson, you heard the date that's been stated by the court. Were you in the city of Romulus? And were you driving while under the influence of alcohol? Your license was suspended. And did you have possession of a narcotic?
Yes.
And you didn't have a prescription for that. Is that correct?
No.
Okay, thank you, Your Honor. I think I'm in complaints.
Miss Pinson, do you remember if you had a blood test or a breathalyzer test back then?
Your Honor, I don't remember. It was so long ago. It's been almost 7 years ago. I don't remember.
All right, give me just a minute. Let's see if I got some paperwork.
And I wrote to you, if I could speak real fast, I wrote to you via
Hold on.
email.
Listen,
You
Miss
want me to
Pinson, Miss
read this
Pinson,
so I
don't-
can take care of the plea, or do you want me to hear you? Because I can't do both.
Oh, okay,
not
I'm
that good.
sorry. I'm sorry. Go
Okay.
ahead. Sorry.
One second.
All right. Ms. Moss, according to the incident report I've got in the file, the blood test results showed a 0.18. So are you satisfied that we've met the, gathered the facts necessary to support these 3 pleas?
Yes, Your Honor.
All right, I'll accept those 3 pleas. I'll dismiss the original count 1. Tell me what's going on with Ms. Pinson. How long is she going to be where she's at?
Your Honor, my client is currently staying at a hotel. She was in a relationship where there was domestic violence and she moved away. Ms. Pinson has indicated that she, since that incident occurred in 2021, she's participating in a rehabilitation program.
So let me stop you. We're getting into the weeds. I want to know how long she's going to be in custody because I've got to have her screened by my probation department.
Your Honor, we're hoping that she will be out of custody. She has a bond that was $500. She could not
In
pay.
our file,
I'm sorry.
is this file the only one she's being held on?
That's the only file.
Oh, I can fix that. Okay.
Okay,
All right.
thank you.
Okay, she got no other cases pending.
She does not.
Okay, all right. So now let's get to where you were going. Does she have a place to stay?
She does have a place to stay. She's staying at the Red Roof Inn, in Farmington.
Farmington
Okay.
Hills. Yeah.
Miss Pinson, do you have the address or do you have an address we should use if we mail you a notice?
Yes, you can, use the address that's on my ID, the 2174 Dickerson Avenue.
Okay, all right.
Yep,
Okay.
because
All
I'll
right, and
still get it.
do you have an email address?
Yes.
Have you given that to one of our clerks?
I haven't, but you should have it because you emailed me like 3 months ago.
right. All right,
For
Heather
this-
tells me we've got the email. All
Yeah,
right, so here's what I'm gonna do. I'm gonna change your bond today so you can get out on the street. My
Okay.
probation department's gonna contact you, probably send you something in the mail to the Dickerson address.
okay,
And email you. We're gonna schedule you to come in for an interview.
okay,
Based on that interview, we're gonna have a report prepared, and that'll be the report that I look at before I sentence you. So
Okay.
counsel, probably the easiest thing is if you'll just contact our probation department and pick a sentencing date with them.
okay. It'd be best for me to contact the
No, no,
probation
no.
department.
Miss Moss.
Oh,
I'm assuming Miss
Judge-
Moss's schedule is much busier than yours.
Judge, could I also make sure that you guys have my accurate phone number as well?
Go.
734-360-5072 and the email missmelissa1001@gmail.com.
We got you.
Perfect.
All right. So currently the bond is,
Miss Melissa. 001.
is your email ms dot?
Yes, ms.melissa1001@gmail.com.
All right. So currently the bond is 5,010%. Yes, Miss Moss?
That's correct, Your Honor.
All right. So as I said, I'm referring for a pre-sentence investigation and sentencing date, and I'm going to change the bond. Ms. Pinson, I'm going to put you on a personal bond, a $5,000 personal bond with a couple
Yes, thank you,
conditions.
Judge.
You're welcome. The first two conditions are pretty obvious. Stay out of trouble and show up in court when you're supposed to be.
I will, I promise.
All right. The third one isn't so obvious, but it's just as important. Do not purchase, possess, or consume any mood-altering substance unless you've got a doctor's prescription. So that means no marijuana, no alcohol. Understood?
Okay. Understood. Thank you,
All right.
Judge.
You're welcome. Miss Moss, did we miss anything?
No, you did not.
Thank
All
you,
right, have
Miss
a great
Moss.
day, ladies.
Thank you, Miss Moss.
You're welcome. I'll talk
Have
to
a
you
good day,
soon.
Judge. Thank you.
Miss Pinson? All right, counsel, your appearance for Sears.
Yes, Nadia Hakeem, P number 87799 on behalf of Miss Sears. Miss Sears is on Zoom in the Wayne County Jail.
All right, and we just need an exam date?
Yes, Judge, we do need an exam date, and I also would like to address bond today.
All right, well, I'm going to need a prosecutor for that. So give me just a minute. We'll get a
Okay.
prosecutor here. Hey,
Thank you,
Mike,
Judge.
ask one of the guys to come in and talk about bonds. So either Kaplan or Muhammad.
Did she fall down? She wants to find talk, yeah.
Her friend's out there waiting. I said, if she calms down, I said, I'll let her out of there. But she's got to calm her things down.
You tell me.
I said, you put her friend in the talk. So don't put the friend in the conference room. And she just got to calm down. She makes me rethink my desire to give her expungement. You might tell her that. Me thinks she may still have anger issues.
He's not a so people. Beautiful.
I'm about to do a bond argument on Sears. Who's our MIDC attorney? Do you know?
For what?
Oh, I'm sorry. Arraignments.
I'm thinking Royce, the Royce is in room 30.
Oh, is he? Okay. Well, and somebody already grabbed the jail. Romulus was on. Somebody grabbed it.
Yes.
Okay. All right, counsel, let's talk about Sears. Appearances?
And good morning again, Your Honor. Nadia Hakeem, P number 87799 on behalf of Miss Stacy Sears, who appears on Zoom.
All right, so by my reading of the file, bond is 25,000, 10% currently. GPS tether, no firearms or ammunition, no assaultive behavior. That's what I read on the file. So make your argument, Miss Hakeem.
That's correct, Judge. Right now, her bond is set at the 25,000, 10%. To give a little bit more context to this case, the allegations in this case are very closely related to the allegations in a different case out of Taylor, Michigan. That case was already filed way earlier than this case. They're directly related. They all kind of come from the same circumstance and date and times, because of course the charge here is fleeing and eluding. The case out of Taylor, I believe there's two cases out of Taylor. Those are in Third Circuit Court, and her bond in those cases are personal plus house arrest. Originally, what had happened in that case is it was a personal to treatment. Since it was important for Miss Sears to get treatment, she went to Don Farm. After that, she was on a personal house arrest to
Let me
her
stop you.
home.
How long was she in Dawn Farm?
I believe close to 2 months.
All right, successfully completed their program?
So they decided that she needed a lesser form of treatment. So she was then put on a personal plus house arrest. And then my office, NDS, was working on getting her into more mental health treatment outside of that. But then, however, because she was on tether and house arrest, she got picked up very quickly after, because this Romulus case was filed months later. But it's not new criminal activity. It all comes from the same circumstance. So what we're requesting now is just for a personal house arrest to get her back into that treatment that we've been trying to get her into. My office has been working very closely with Miss Sears. Her bond in the other cases, again, is the personal house arrest. And we are still trying to get her into that treatment. That would be very helpful for Miss Sears here.
Mr. Muhammad,
The defense reflecting modified on to house arrest.
and lower it from 25,010 to a personal. So the lady can get into treatment. Basically to mirror what's going on in Third Circuit, I think is what you're saying.
Today's courtroom featured several powerful reminders that every case is different, but respect for the court remains non-negotiable. We watched one defendant's repeated interruptions lead to immediate contempt consequences, another defendant receive a stern warning that probation violations can quickly escalate into lengthy jail time, and others receive opportunities for rehabilitation, treatment, and second chances under strict legal conditions. Throughout each hearing, the judge balanced accountability with fairness, showing that courtroom decisions are based not only on the facts of each case, but also on a defendant's actions and attitude inside the courtroom.
Correct, Judge. She was out for a while, and then she got re-picked up on a newly filed case. But again, not new criminal activity.
Right.
I would have no objection to house arrest with a GPS penalty.
Okay. All right. We didn't pick an exam date yet. So when are you ready to do that?
Judge, I believe we had spoken off the record about July 7th at 11 a.m. That is when I would be available.
Okay. It's currently scheduled next week. Can you do that or not?
Unfortunately, no.
Okay. All right. July 7th, Mr. Muhammad?
Yeah, that works.
Heather, what time you want to set that?
I think, was that the time we chose?
Correct. Yes, July 7th, 11 a.m.
Okay. All right. And Miss Sears, I'm going to change your bond. I'm going to put you on a $5,000 personal with GPS tether house arrest. Got that? All right. You're muted. There you go.
Thank you.
Understood? All right.
Yes,
Raise
sir.
your right hand.
Yes, Your Honor.
Do you swear or affirm and acknowledge the debt payable to the court in amount of $5,000 if you violate your bond? Raise your right hand. Do you swear or affirm?
Yes, I swear.
All right, you can put your hand down now. Bond condition number 1, stay out of trouble. Bond condition number 2, be where you're supposed to be as far as court dates. Counsel, anything else?
That's all, Judge. Thank you.
All right, thank you.
Miss
Thank
Sears,
you.
just get in contact with me right when you're released, okay?
Thanks, Mom.
Okay.
All right. Thank you, Judge. Have a good rest of your day.
You as well.
He pointed out that having a receipt for some items didn't prove payment for everything. Then came the crushing warning. If the evidence showed the defendant took food without paying, he could face up to 90 days in jail. The courtroom fell silent as the judge made one thing clear: accountability matters, and excuses won't save you.